I just can't tell.
Yeah.
All right. Hey, everyone. Welcome to the Business Samurai podcast. Got another fantastic episode for you today. With me is Morris Turek. He is my trademark attorney. And actually, if you go to yourtrademarkattorney.com, he can be yours as well. Morris helps entrepreneurs, businesses, and organizations avoid the devastating and disastrous effects of being sued for trademark infringement. He does this by clearing and protecting the names, logos, and slogans they use to advertise and sell their products and services. His practice is devoted exclusively to trademark matters, including trademark search and clearance, federal trademark registration with United States Patent and Trademark Office, trademark registration maintenance and renewal, trademark opposition and cancellation matters, and general brand protection and enforcement issues. Morris has been practicing trademark law since 2005 and has had his own trademark law practice since 2009. As mentioned before, you can learn a whole bunch more about Morris by going yourtrademarkattorney.com. And I kid you not, before we jumped on, Morris doesn't know I did this. I actually just Googled trademark attorney, and he's like 4 or 5 on the list of the main page just by using the generic term. And you got your ads, but then Morris is right there on the first page. So
I must be doing something right. Thank you.
You are absolutely doing something right. I was just curious. I was curious with the domain. Morris, thanks for taking the time.
Oh, it's my pleasure. Thanks for having me.
So, what did I miss in the bio? Is there anything, any notable things that I've missed?
I don't think so. I think that pretty much covers it. I'm a trademark attorney here in St. Louis, but I serve businesses and entrepreneurs located all over the world.
So, I've seen a lot of Law and Order SVU, but I haven't seen Law and Order Trademark Attorney.
No.
So
that would not be a very interesting episode.
Well, I guess that's what kind of curious. What was the drive? What was the niche to get into that? Because I know a lot of criminal defense attorneys. I know civil, your family attorneys and things of that nature. But what was the interest in trademark?
Well, I fell into it. I was working at a law firm in Illinois as a law clerk during my second year of law school. The summer after my second year of law school, I was working as a law clerk at a small law firm in Illinois doing class action litigation, which was terrible. But, it was a good legal experience. And I actually started dating a girl named Karen. And
it's always the female, man.
Yeah, this is. I mean, hey, it all worked out, but well, not with Karen, but it all worked out for my career. So I through Karen, I met another trademark attorney. I met a trademark attorney named Annette, who is Karen's aunt. And while I was working at the law firm in Illinois, Karen's aunt contacted me and asked if I would do some research for her on a project she was working on, and she would pay me and just do a little research on the side. I did. And then she asked me to do another project during the summer, which I did as well. And then after the summer and starting my third year of law school, she asked if I wanted to become a law clerk for her and learn trademark law. And I said, well, I hate what I'm doing at this law firm now, so sounds good to me. And so that's how I fell into trademark law. So I started working for her a few days a week after classes, and that's how I learned it, and that's how I fell into it.
Gotcha. So in your law school days, is there like general courses that no matter what type of legal profession you're going into, everybody takes, and then you pick a niche, or was this something that was totally like on the job training?
Well, during the first year of law school, you're required to take certain classes, none of which are trademark law, very general classes like property, criminal, constitutional, things like that. After your first year of law school, you have more leeway on what you want to take. I did take trademark law. I also took copyright law as well. But I took trademark law after I had started working with Annette already. And so I sort of had a one-up on everybody in that class because I was getting actually practical experience and I kind of understood what was going on. In fact, I ended up getting the highest grade in the trademark class and got a little, I forget what they call it now, but it's a little award you get at the end of the semester for having the highest grade in the class. But I felt like it was a fraud because I had so much more experience than anybody else in the class. So.
Okay, but you weren't like teaching the teacher at that point.
I was not teaching the teacher, no. But it did give me a really, really nice foundation for the class. It was great.
Oh yeah, no, I
Yeah.
imagine. So how often, we every year, I keep a track of like state laws and hey, we've got new motor laws, we got stuff like that. How often this trademark and copyright law actually get updated? Is it frequently reviewed like other areas?
It does. I mean, I would say law in a lot of different areas is fairly slow to change. Recently, though, there has been a lot of U.S. Supreme Court decisions in the trademark and copyright fields. For example, just a couple of years ago, there was a case having to do with an Asian musical band called the Slants, and it was basically about whether the trademark office could constitutionally prevent the registration of trademarks that are seen as disparaging of a group of people. This
Oh,
Asian band wanted to register the name the Slants, and Slants is sort of a derogatory name
yeah,
for Asians, and they were initially refused. They went all the way up to the Supreme Court on this, and they got the law to change. The Supreme Court, knocked down the prohibition against the registration of disparaging marks. And there's been a number of other trademark cases as well. The Booking.com case, which was very recent, ruled that a name plus the .com is not necessarily generic. So, like, now it may be possible to register things like law.com or computer.com if it's, whereas before you couldn't. And so that's been a change in the laws as well. And I'm simplifying that, but yeah,
sure.
there's been some changes. In fact, just yesterday there was a copyright case out of the Supreme Court about copyright registration and about what happens if there's a mistake on the copyright registration, and is the copyright registration still enforceable? So yeah, so things are happening. Things are and
Those aren't the ones
happening at
that
the
make the
highest.
news.
So yeah, right. Now there's a lot of trademark litigation because it's a bunch of businesses fighting over stuff. There's a lot of trademark litigation. Most of that never gets to a decision, and most of it certainly never gets appealed, where you get like a reported decision on a interesting point of law. But yeah, there's plenty of litigation, and laws do change. More so with trademark registration, the procedures have changed a lot. Sort of the ways to challenge trademark applications and registrations have changed. There's new procedures called expungement and reexamination that were just put into effect this year, that have opened up some more avenues for attorneys to challenge trademark registrations that may be fraudulent or improperly issued. So, yeah, there's lots of different things. In fact, one of the more recent ones too about foreign entities. If you're not located in the United States, the trademark office just a couple of years ago made a rule that says you have to use a U.S. attorney. You can't do it yourself
Oh
anymore.
wow.
You have to
Okay.
use a U.S. attorney, which of course now opens up a nice chunk of business for U.S.
Right.
attorneys. So I'm not complaining.
Like somebody that happens to be on the homepage of Google.
Hey, if it's going to benefit, I mean, if it's just going to benefit me, I mean, I'm not gonna say no. But it's been a nice, especially like out of Canada and Australia and the UK.
Sure.
Because with Amazon and all these other online platforms, it's easy for these people to sell in the United States. I mean, it's a huge market, and now they want to protect their trademarks and their brands in the United States. And here I am, ready to help.
Gotcha. How often, speaking of going to the Supreme Court, how often do these in infringement cases actually go to, like, I don't know if they go to like jury trials or things of that nature? How that process work? Is that frequently that happens? There's some risk reward metric that goes, hey, we're going to really push the button on these guys because they're selling our logo on something else? I imagine this is probably the bigger the company, but how often does that happen?
Yeah, I mean, like every other area of law, most litigation never goes to decision, never goes to trial.
Okay.
Never, because number one, it's very expensive. Number two, litigation is very uncertain. You might think you have the best case in the world, but who knows what a jury is going to do or a judge is going to do. And plus, you don't, sometimes, usually these trademark disputes and copyright disputes, I mean, these are really just business disputes. And do you want a judge or a jury of 12 people who don't even understand your business necessarily making the decision? No, you'd rather have the two business people kind of come into some kind of agreement, some kind of compromise. So yeah, very a tiny percentage ever go to a decision, and then even
Gotcha.
a smaller, like an infinitesimal number, go to appeal. And that's where all the action is really on the appeals. Very small amount.
I don't know how much this is going to be completely off the wall, and I'm by no far an expert. But have you been tracking what's going on with the NFTs, the non fungible tokens?
Um,
I'll lead it with that before I go into a secondary where my real
yeah.
question is at.
I'm not going to lie. I'm not really up to date on NFTs, though. My associate Kevin is a little more into it, and he's sort of teaching me a little bit more about it, which is good. But yeah, it's huge. Actually, a case has been recently filed by I don't know how you say it, Hermes or Hermes, Hermes. It's like the fashion brand. They recently,
The expensive
yeah,
fashion
yeah, the
brand,
big
yeah.
luxury brand. They just
Yep.
filed a suit recently against somebody who's been using and created a whole bunch of NFTs with having to do with one of their bags, Birkin. I'm not sure. I know maybe somebody out there knows what I'm talking about. But
They sell T-shirts for like $500, so
yeah, I mean, I don't. I would never know anything about this, but anyway, but yeah, but it's getting big, right? Because now it's like you're not even now these brands, especially these well known brands, now they have to protect their trademarks against virtual goods, metaverse things. Again,
right.
I'm not versed in the metaverse, but
Yep.
but these are all things I'm going to have to learn about as they become more and more prevalent. So
And I guess that goes into where I was thinking where you see this could head, because people are able to sell a share in quite frankly, it could be a share of their brand. Some of the stuff that I'm hearing about is, where you're seeing everybody buying these NFTs of the monkeys or whatever,
mhm.
but you're going, hey, I've copyrighted this, I've trademarked this, but at the same time I'm going to flip it into an NFT, so you and sell somebody the rights to that. I don't know how the level of complication from a legal perspective that may, well, it probably is starting to turn into that now, but could really explode over the next several years.
Yeah, this is going to be huge, as well as like things like cryptocurrency.
Mm-hmm.
This is the big one now, and lots of other different areas, that are starting to really grow. There's a lot of intersection, from what I can tell, between trademark, copyright, NFT, these virtual goods, and they're all going to kind of play together. I did recently just see a news article. I think it was on. I was watching TV. I think I saw it on Fox News. It was just a story yesterday about the somebody was killed. Um, the killing of somebody was streamed online. It was a young woman, and um, the father of the victim is trying to get the media to stop playing this footage. Now, the father is not the owner of the footage of the video, right? He didn't shoot the video. Somebody streamed it. Whoever streamed it
Sure.
is the owner, whoever he sold it to, but it's not the father. And then so he was talking about how he was speaking with some legal counsel, and he wants to try to make an NFT out of this video in order to try to prevent its um, broadcast and dissemination. Now, I didn't really understand it because, well, if he's not the copyright owner, how can you make just an NFT out of something you don't even own? I
Right.
didn't I didn't quite understand that, and maybe somebody out there can explain this to me. But it was interesting how they're trying to use NFTs to try to circumvent somebody's copyright in this footage.
That's something I had been thinking about, going even with what I've been doing with you with the Business Samurai logo and the name together, going, what would really stop somebody that got creative and said, hey, that's kind of cool looking or whatever, or I want to screw with somebody, and they go through the minting process, I believe is the term, and turn it into that fungible token. What is to stop somebody from doing that? And then you get a dispute outside of me going, hey, Morris, man, you got that where's that stuff on the US website that I can go, no, I did this like 3 years ago. I'm
Yeah.
wondering where that intersection is going to be.
Yeah, I think it's brand new. I don't think anybody really knows, and until we start getting cases filed and decisions from judges and juries, and especially those that are appealed, we're not really going to have a lot of answers. Um, Certainly, this isn't going to. I think it's unlikely that this stuff is going to happen to sort of the quote unquote the run of the mill trademark,
Sure.
because, like, what's the value? But like
Right.
I think luxury brands, very well known brands, famous brands, yeah, I think they're going to run into a whole bunch of it. I mean, like I said, Hermes is already running into problems.
Interesting. Yeah, no, it's going to be interesting. And also from you just see the way the political process works. I mean, you got a lot of aging lawmakers that may be going, what is this? Having watched enough congressional testimony in my life to go, all right, dude, you're talking about an iPhone as you're flashing around your Android or vice versa.
Yeah, I mean,
I don't have a lot of hope for blockchain technology.
yeah, but I tell you, it is very interesting. And like I said, my associate who's younger than me, he's like 7 or 8 years younger than me. He's kind of getting more into it. So he's like I said, he's kind of educating me on it, which is nice.
Cool. All right, well, let's shift gears a little bit. So somebody's got an idea, or they did, like, just in point blank. I sit there and had an idea. I had read a book that's like, everybody should have some sort of something that they can trademark, and it was from a consulting standpoint, that was something that they could lay back on. I can't remember the reasoning. I had read that years ago, but when should a company reach out with something that they've developed and go, hey, I really need to look into getting some protection behind this my brand?
Mm-hmm. Just to kind of give some background, obviously trademarks are brands, right? Trademarks are names or logos or slogans that are used in connection with the advertising and sale of products or services. And really, unless you're using a completely generic name, like you run a pet store and you called yourself Pet Store, if you did that, then you don't really have a trademark. But
Right.
most people don't do that. Most people come up with some cool little name for their business or their organization, or whatever it might be. So everyone's got a trademark. The question is, does when does it come time to want to register it federally, protect it federally, and registering that trademark with the United States Patent and Trademark Office, the USPTO, gives the owner of the trademark the exclusive nationwide right to use that mark in connection with the products and services that are listed in the trademark registration. So somebody who might only, let's say, for example, let's say somebody has a restaurant and they call it ABC Restaurant. Terrible name. Hopefully nobody did that. But, let's say there is an ABC restaurant and they're just operating in St. Louis, Missouri. Without a trademark registration, their rights will extend to the St. Louis metro area, essentially, right? However, if you get the trademark registration, if you register the ABC restaurant federally with the United States Patent and Trademark Office, then your rights now have expanded throughout the nation, not just St. Louis. What does that do? It blocks other people from using a similar name for similar services anywhere in the United States. And if they do, then the owner of the trademark has the legal ability to stop that infringement. So that's the power of the registration. So when do you want to get the registration? Well, there are business considerations and there are legal considerations. Let me talk about the legal considerations first. The legal consideration is you want to file as early as possible with the trademark office, because the day you file is the day that you reserve the exclusive right to use the name. So if you wait, it's possible that somebody else might file the trademark application for a similar name for similar products or services, which would then exclude you from using your name for your products and services. So from a legal perspective, it's really good to file as early as possible, even before you start using the name, because you can file a trademark application on an intent to use basis to reserve the name. It doesn't have to be in use yet.
Which is what I did.
Which is what you did, right? And which is what I'd say 80% of my clients do. The intent to use system is great. It's great for businesses. Now, excuse me. Now, from a business consideration, well, now we're really talking about, is my business even going to be successful? Am I even intending to operate outside of my local area? Like, if I'm a gardener and I only provide gardening services in my local area, I don't think it's probably worth getting a trademark registration. What do you need it for? You have your little rights in St. Louis, Missouri, and you're fine, right? But if you sell products, and that you could sell those products on Amazon and anywhere else, and they could be shipped anywhere in the country, then I think getting a trademark registration early makes sense. Now, maybe from a business consideration, maybe your product is going to be a dud, right? So now you start selling these products, you're not making any money, and now you spend money on a trademark application that isn't going to go anywhere because you're going to fold your business. So what do you need the trademark registration for? Nothing. So that's, so it's kind of like you're kind of balancing the legal and the business considerations.
Gotcha. Yeah, no, that totally makes sense. What for people not familiar with it, what in a condensed form, what is the process like to go register?
Well, the first thing we generally recommend doing is performing a search on whatever trademark it is that you want to register, some kind of name or slogan or tagline or something like that. We would generally want to do a comprehensive federal trademark search on the name to check for conflicts or issues that would prevent the successful registration of the mark. And that search is, we usually have those kinds of results in about a week. And then based on those results, if the trademark looks clear, then we can file a trademark application with the USPTO, and that reserves it as of the date of the filing. Now, it's going to take the entire registration process is probably going to take over a year, and sometimes quite a bit longer than a year, depending on a lot of different circumstances. But again, all of your rights date back to the filing date of the application. So let's say it took 3 years to get a trademark registration. All of your rights date back to the day you filed. And if anybody started using a similar trademark for similar products or services during the pendency of the application, then that person would be an infringer, and you could stop that infringement.
Yeah. Yes, and I remember when we were talking back, I want to say the initial kickback for me was about 18 months, I believe. What are some of that I'm guesstimating because it's been long enough now.
Well, yeah.
But what are some of the extenuating circumstances? Why does that process take so long to hear back from them?
Yeah, well, in your case, there was a little bit of a wrinkle, but generally speaking, it takes right now it's taking the trademark office about 7 or 8 months to even look at your application. Okay. Now, once they look at it, let's say everything's good, they do their own search, they didn't find any conflicts. Then it goes through what's called a publication period, which is a 30-day period where anybody can challenge the application or oppose it. Assuming nobody opposes it, then it goes to the next phase. If the trademark application was filed on an in-use basis, meaning that the trademark was already being used at the time you filed your application, then the registration issues. But if it wasn't being used at the time you filed the application, then what's called the notice of allowance issues. And then you have to show use of the mark to get the registration. And you have 6 months from the notice of allowance date to show use. And if you can't show use in those 6 months, you can get an extension for another 6 months. And you can actually get up to 5 extensions, 6 months each. So you can actually hold the trademark application open if you wanted to for like 4 or 5 years from the date that you file, if it's an intent to use application. Now, what are some of the extenuating circumstances that makes that process even longer? Let's say you get a rejection. Like, let's say the trademark office reviews your application and says, hey, we think there's a confusingly similar trademark that's already registered. Well, then if the owner of the application wants to try to argue around that rejection, argue against it, then we can prepare and file a response. Of course, then that takes time, and then it takes the trademark office time to review that response. And so that makes the process longer. Another thing that would make the process longer is if somebody challenges the application, opposes it, or if somebody, in your case, John, what happened with you is that someone actually filed an extension of time to oppose your application, if I remember correctly. And
it's something like that.
Yeah, something like that.
It's been so long now.
Yeah.
I remember something weird.
Somebody filed an extension. So they were considering, somebody else was considering opposing, but chose not to. So they kind of stopped your application. I think it was for like 90 days. And then they decided not to file an opposition, and then your application went through the process. So that delayed it by another 90, 120 days. So those are the kinds of things that make the process longer. But again, people kind of get hung up on like, oh my God, this is taking so long, blah, 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 blah. It doesn't matter how long it takes from a legal perspective. It could take 10 years. All of your rights are going to date back to the filing of the application. In fact, I had a client recently whose application has been put on hold for a number of reasons. I won't go into it, but for a number of reasons, it's been on hold for 5 years, over 5 years now.
Wow.
And it's just the way the process works. There's not, when this happens, there's not a lot we can do. We sort of have to just play the waiting game, but it all worked out at the end.
Excellent. So, okay, we go through the process. You get approved. It's in use. What is necessary then to keep it through that renewal period? What are they looking for? How often do you go through that process to check in and say, "Yep, still active." I'm I'm the Pepsi of whatever I'm doing. It's still going on.
Sure.
What's that process like?
Yeah. So currently, the first renewal or they call it really a maintenance period is between the fifth and the sixth year of registration. So once you get your trademark issued, you really don't have to do anything for 6 years. So you have to maintain the registration between the fifth and sixth year of registration, and that requires filing what's called a declaration of use, and that basically tells the trademark office that yes, I'm still using the trademark. Here's some proof of that, and then they will renew your or maintain your registration. The next period is really a renewal period, and that renewal period is between the 9th and the 10th year of registration. That renewal period, requires that you show use of the mark. You file what's called, a declaration of use, and a request to renew the registration. And assuming it's accepted, then your registration doesn't need to be renewed again for another 10 years. So it's not really onerous, or it's not even all that expensive when you divided by the number of years that the registration is active before you have to do anything. It's not even very expensive. But you have to kind of remember to do it. Thankfully, the trademark office does send out reminders over email to tell you, hey, it's time. If you have an attorney, then it's in their system. So we send out reminders.
Right.
But yeah, it's certainly not as onerous as some other types of law where you have to renew things every year, or file annual reports on your corporation, things like that. So yeah, it's actually really pretty simple.
Straightforward.
Yeah.
Cool. One of the things I heard something, I can't remember what I was listening to about somebody filing a very weird trademark thing. And I know the process that we went through when you were looking up Business Samurai, and we had to combine the name and the logo versus having them as two separate entities. I do remember that. But I came across, I don't know if you can see it on your screen. I was trying to find the recent one of what I heard on the radio, and it was so obscure. I'm sitting there going, how can you trademark that? That's how common the phrase was. But coming in during that research, I came across this website that was like, T-Mobile has copyrighted the magenta color, and I'm why or how did they get away? How did those bigger companies get away with like copywriting color? Is it very limited that like I can't be a telecommunications company selling cell phones and use magenta because they copyrighted not the name but the color, like the hex color?
Mm-hmm.
What's the nuances when you start getting into splitting hairs with stuff like that?
Yeah. Well, just to be clear, we're not talking about copyright. We're only talking. This is trademark. So they didn't copyright the color. So it's trademark. But
see, and this is me being stupid on how I'm even asking the questions. So
well, I just want to clarify. So you're right. You cannot copyright a color. That's not possible, right? Now, what you can do though is you can protect a color as a trademark for specific products or services. T-Mobile's magenta color is an example of this, right? Now, it's very hard to do, right? You have to be able to prove to the satisfaction of the trademark office that consumers associate this particular color with this particular product or service. Now, that's very difficult to do, right? I mean, if you're just a small business, that'd be impossible for you to prove, right? But when you have millions and millions of customers and you do surveys and you say, hey, if I show you this color, what service does this remind you of? And they say T-Mobile. Well, that's very good evidence that this has now become a trademark. People associate this color with a very specific service or product from a very specific business. Another example of this is the Kodak yellow. I know I'm dating myself here, but if you remember like the film boxes from Kodak, they were all this like goldenrod. That was also a trademark of the Kodak company. Another example is the pink color of Owens Corning insulation, home insulation. That pink color, the Pink Panther insulation, that pink color is a trademark of the Owens Corning Corporation because people associate that pink color with that installation and only that installation. And so over time, that became a trademark.
One of the ones I found interesting on the screen was the term superhero.
Oh, yeah. Yeah, but that's Marvel. It's DC or Marvel, I think.
It's both.
Is it both? Yeah. Oh, is that what it is?
That was what it was just, it happened to be on this. Again, I was not looking for this specifically, But I found that to be interesting that Marvel and DC had trademarked the term superhero,
That's that.
particularly in this particular movie age that we're in.
That's absolutely true. And there are many other types of trademarks, and which I didn't touch on, but because they're more rare. But like, for example, sound can be a trademark. A good example is the NBC chimes, ding ding ding. Certainly a trademark. I didn't even have to say NBC chimes. I could have gone ding ding ding, and you would have known exactly what I was talking about. Or like the Red Robin, like Red Robin, yum. Also a sound trademark.
The Law and Order, the dumb was on the.
Yep.
was one.
Yep. Yeah, absolutely. Those are trademarks. Also, scent can be a trademark. Now, this is very, very rare, exceedingly rare. But very recently, I'd say within the last 2 or 3 years, the company that manufactures Play-Doh, I think it's Hasbro, but don't quote me on that. They were able to achieve a trademark registration for the scent of Play-Doh. And when you think about it, like you and I, we're not kids, John, right? And we probably haven't smelled Play-Doh in decades. I know I haven't. I don't have kids. Maybe you do. I don't know. But I haven't smelled Play-Doh in decades. But I still know what Play-Doh smells like. If you put something in front of me, cover it up, and I smelled it, and it smelled like Play-Doh, I'd be able to tell you that was Play-Doh. And so they were able to get a trademark registration because people associate that scent with that product. So it's a trademark.
Is that, I guess, then perfume and cologne companies would do things of that nature if you've got something that was very distinct.
You could, it was
very distinct.
It's got to be very distinct. But again, like with the problem with perfumes and colognes, right, is that people expect perfumes and colognes to smell a certain way, right? Sometimes flowery, sometimes spicy, whatever it might be, right? So it's harder to prove that that a consumer actually associates a very specific scent with a very specific product. I think that's tougher to do. I'm not saying impossible, but when you have something like Play-Doh, a clay, well, clay doesn't usually have any scent. And if you do, it's like you don't think of the scent as being a part of the product. Like it just happens to have a scent because that's the way it was manufactured and it just smells that way. Right. But that's not. But with Play-Doh, it's like people know what that scent is. Like you can open up the canister and be like, oh yeah, it's the Play-Doh scent, it's a little bit different than for like colognes and perfumes because those are supposed to smell. Whereas clay, it's like, that's not the purpose of the product.
Got it. Something that I had an issue with, this was a long time ago, and I'll be honest with you, now that you've corrected me a couple times, I'm still confused a little bit between copyright, trademark.
Well, do you want me to give the difference real quick?
Yeah, please.
Okay, so trademarks are names, logos, slogans, smells, colors that are used to advertise and sell products and services, right? They're used to distinguish between certain types of products and services. So, for example, if you had two dark bottles of cola on the store shelf and none of them had a label, you wouldn't know if you were buying Coca-Cola or Pepsi or Dr. Pepper or whatever. We need trademarks to identify products and to distinguish between them, right? And services as well, right? You need to know, when you go to a restaurant, it's got to have a sign on it or you don't know what restaurant you're eating at, right? It's got to say McDonald's or Burger King or Taco Bell, right? So you see all the fancy places I eat, right? So then, so that's a trademark. It identifies the source of the product and service, and it helps consumers distinguish between products and services. Now, what's a copyright? Copyright protects original works of authorship. So, for example, books, movies, music, drawings, paintings, sound recordings, things that are original. Things that are more creative, though copyright doesn't necessarily have to be creative, but when you think about copyright, you kind of think of like original creative works.
So, okay, and I guess this is, and I've seen on your website, but I guess explain the difference then of when you would use the TM versus the C in the circle. And I think that's why I see, I guess, once you get it fully adjudicated, or I'm going to use the term adjudicated, but you can slap me on that one too. But to start using the C versus the TM, can you explain a little bit of how that?
Well,
to identify it.
Yeah, well, you're crossing two different types of intellectual property, right? The circle C is for copyright. So when you write a book, you might say in the inside cover, you're going to write, like if you're the author of the book, if you're the copyright owner of the book, you're going to write circle C, and then if I wrote it in 2022, I'm going to write 2022, and then I'm going to write Morris Turek. That's
Okay.
copyright notice. It tells people who owns the copyright in the book. Okay. When you watch a movie at the end of the credits, it always says copyright whoever, Sony Pictures, right? That tells you who owns the copyright in the movie. Now, the TM is a symbol that you may choose to use in connection with your trademark. So, for example, if I open up a restaurant called ABC Restaurant, I could put a little TM next to ABC Restaurant, regardless of whether it's registered federally as a trademark or not. I can use the TM. If you have a federally registered trademark, so let's say I federally register ABC Restaurant with the USPTO, then I can use the circle R symbol, the R in the
Okay.
circle. So copyright's a C in a circle, trademark is R in a
All right.
circle.
Gotcha. I'll save my story then, because the issue I had years ago was a copyright issue on photos that does not apply necessarily to this. Now that I know the differences.
Glad I could clear it up.
Yeah, no,
Yeah.
thank you. That helps, because sometimes I can be slow and dense on certain things.
That's very confusing. In fact, it doesn't help when you hear you're on the you listen to the news and they use these terms, patent, trademark, copyright. They just use them interchangeably, like as
Right.
if they're the same thing, and it's very confusing. But yeah, they're very different. They protect different things. So yeah, it's important to know the differences with these things.
Once you've got it, you've got it approved, everything's in the system, right? And let's say you have built up, your brand to be at a significant point where you're going out there to make sure there's no infringement. How do you maintain that knowledge of somebody is doing something they're not supposed to with it?
Well, when you're a big brand, let's say you're the Nike of the world, right? The
Mm-hmm.
Google of the world, the Amazons of the world. They have teams of attorneys that hire these trademark monitoring and trademark watch services that basically scour not only the trademark office's records, but also uses throughout the internet. They have these tools that basically will try to find infringements, and then
Right.
if as the trademark owner, you can address those infringements. Now, if you're a big company with tons of money and tons of attorneys, well, okay, you can do that all day. When you're a smaller outfit, it's not expensive to monitor, to have a monitoring service. But the question is, what then do you do with that information? Let's say the monitoring service finds a few infringements of your mark. Okay, well, you're a small fry. Do you have the money to actually pursue this? Do you have the money to go to court? Uh, I know I tell you, a lot of my clients don't, and I represent very small and startup businesses. So it's one thing to have the knowledge of the infringement, but then what do you do with that?
Mm-hmm.
Um, I generally, I, I don't believe, and some attorneys might disagree with me, especially ones that represent larger businesses, but I, I don't think it's a great idea to just go seeking out infringements. I don't think that makes a whole lot of sense. What I do think makes sense is if you run into one. Like, for example, a customer comes to you and says, "Hey, did you know that somebody's using this mark? And it's very similar to yours, and I thought it might have been you." That shows that there was maybe some confusion, right? And that's when you might want to look into that and maybe take some action because it was brought to your attention. But to just go seek these things out, just to be sending cease and desist letters and getting into litigation, doesn't seem to me to make a lot of sense.
Is there fair use with some of these ones, particularly with the bigger ones, where if you're doing news stories or
Mm,
things of that nature, where you can actually use them without facing consequences?
Yeah, absolutely. There's fair use both in copyright and trademark. But yeah, absolutely. Like if you're reporting on something about, say, Nike shoes, you have every right to use the term Nike to describe those shoes, to refer to those shoes. It's what we call a nominative fair use. And there are other fair uses, parody, satire, things of that nature that you can use trademarks to, make a point. Um, those are not really those don't tend to be the infringements that businesses, especially even like larger brands, care
Mm-hmm.
about as much. Like, yeah, they may not be happy with a satire or a parody, but they're not going to attempt to really stop you. Really, they're more concerned about these things, especially like if you're like the Nikes of the world, like counterfeit products coming into the USA with the Nike
Sure.
swoosh on it. That's what they want to stop. Even though these big companies, they have limitless resources, I think they do tend to pick and choose their battles, especially in the internet age where it's just whack-a-mole. You try to stop one thing and another thing pops up. So I think it's made them more. I think the internet has made them have to pick and choose their battles a little bit more than maybe they used to. So yeah, because they'd spend every day, all day, just trying to crack down, and it's never going to work.
I've seen a mix of this, and again, there's going to be bleed over between some trademark with the brand as well as copyright with what I see on YouTube,
Mm-hmm.
where what I see some creators complain about getting dinged on for fair use, and then I'm watching another one upload an entire movie trailer to their channel, and it's got 1 million views, but the guy that's got 10% of that is constantly getting the demonetization. So are they picking winners and losers in that battle? I've tried to reach out. I actually want to talk to some of them from a business standpoint on how that functions. But it feels like some of those companies on that enforcement front are picking winners and losers in that category because they don't like them or not. I don't know.
You might be right. I again, and that happens. But that's more on the copyright side than the trademark side.
Yes, correct.
Yeah, which I do some copyright work, but the vast majority of my practice is trademark. The bigger problem in the trademark arena right now are people who register trademarks with the trademark office, and maybe these trademark registrations are questionable at best, okay, and downright fraudulent at worst. And then they use these registrations in an unfair manner to take down their competitors on Amazon and Etsy and other selling platforms, which then, so then they're clearing their competition, right? And what's bad about it is that the victim, what I'll call the victim, whose stuff was taken down, these platforms, like, it's impossible to get it back up without the person who sent the takedown notice, without their consent, without their permission to put it back up. It's almost like guilty until proven innocent. And I kind of get it. Like, these companies don't want to be arbiters of IP disputes, and really, should they be? No, that's why we have courts to. And if I was running like Amazon or Etsy and some of these other eBay, things like that, I wouldn't just take down a listing because somebody showed me a trademark registration. I would at least give the other side a opportunity to respond before taking it down. But these platforms, they're so crazy. They're so crazy.
Right.
And then it's because I represent some bigger Amazon sellers, and I've had times when, like, somebody with literally a fraudulent registration has taken their stuff down, and they have had so much trouble getting their stuff back up. Luckily, some of my clients are such big Amazon sellers that they have some,
they got some pull.
They got some pull, and they know who to talk to at Amazon.
Sure.
And they can get these things resolved. But your average person, oh my God, it's like the Wild West. It's like the Wild West. And if I just say one thing, these places like Amazon and Etsy, they for some reason believe that just because you have a trademark registration means that you have some legitimate trademark rights. I mean, that isn't the case. Trademark registrations are obtained fraudulently all the time. There's false and misleading information in trademark registrations all the time. It's also possible that someone who got the trademark registration actually achieved it after somebody had been using it, right? Let's say I've been using a trademark for 20 years and I never registered it, right, with the trademark office. And then somebody else gets a trademark registration for the same name for similar products or services. I was first, and now you're taking me down? But these platforms like Amazon, they don't care. They don't even consider it. They just take down your listing, and then it's up to you to figure out what to do.
Gotcha. Is there something, if somebody's starting out and they're kind of going, what's out there? I want to be creative. I want to come up with something. Is there an easy way for them to start doing some pre-research if they know they want to go down the legal route and not kind of get themselves in trouble?
Yeah, I mean, they can go on the trademark office's website. They have a very basic search system called TESS. and they can type in a word or a phrase and kind of see what comes up, see if they see any conflicts. Now, again, you kind of have to understand what you're looking at. I mean, this is the problem, right? You might get a list of 100 marks, right? And you could go through each of the trademark applications or registrations and see, kind of what it says. But unless you are familiar with trademark registration, a lot of the information in these registrations and applications isn't going to make a whole lot of sense to you. It would be like putting, it would be like putting like a book of Chinese in front of me and saying, "Hey, interpret this." Well, I can't read Chinese, so I'm not going to be able to do that. Um, so the better option is to have an attorney do a search on whatever it is that they want to use, and then that attorney can give you can do the search and then give you an opinion as to whether there are any conflicts or issues with using and or trying to register that trademark with the USPTO.
Awesome. Now, if somebody reaches out, is there like a preferred list of things that you would prefer that they have together that to give you right off the gate? Is there stuff that that annoys you, that somebody comes in and says, "Hey, I've done these things," and you're like, "Why did you do all of this stuff? You made my job harder." How do you prefer to new clients to approach you with the process to make it as simple as possible?
Yeah. Well, I think the internet has been very good and very bad. So,
Words of wisdom.
yeah. Yeah. So everybody, doctors must feel this way too, right? When the patients come in and
Sure.
say, "Man, I was WebMDing this, and I know I have some rare disease out of Africa. I must have it. Because I have all these symptoms." And the doctor's like, "You have a cold." So but is it great that people can research and learn on the internet? Absolutely. That's wonderful. The same is true for trademark. There's a lot of information out there. My website is chock full of information about trademarks, and the trademark registration process. But when people come to you and they've done all this research, and they believe that they understand what's going on, 9 times out of 10 they really don't. They don't understand obviously they don't understand the nuances, because unless you're an attorney and do this all the time, you don't really understand the nuances. But they also don't always understand the basics. I don't expect them to know the basics. They don't need to know anything about trademarks when they contact me. I can educate them. It doesn't take me very long to do that. But
Unless
the
you're me.
problem, no comment. But the problem is that people come to you and they think they know, and then you say something like, "Well, it's great that you did this research, and it's great that you used tests, and you didn't apparently find any conflicts. Great. I recommend now that we take the next step and do a more comprehensive search to make sure that there are no conflicts or issues." And then they say, "No, it's fine. I did my search. I did my research. It's all good." And you try to explain to them, "Well, yes, you did your search, but that's a cursory search. That's a rudimentary search." Try to explain it to them. But sometimes they feel like they've done everything they needed to do. Okay, well, you're not going to convince some people. Fine. The people who come to me are the people I like the most. The people that are easiest to work with are the people who are open-minded. People who have maybe done like a little bit of research and have kind of gotten interested, but they have questions. Of course, you're going to have questions. They're willing to listen. They're willing to be open and honest about what they want to do. Sometimes people come to me and they want to be a little shady. They want to try to do something maybe a little shady, which is fine. Maybe we can do something shady. We gotta look into it. But then they feel like maybe even like a little embarrassed talking about it, especially if the product or service may be a little risque. That's possible. So, but yeah, So the people who come to me that I think we have the most success with are the people who have done maybe a little bit of research, have an open mind, and are willing to be open and honest with me about what they're wanting to accomplish.
Awesome. You actually triggered a couple things as you were talking. One of the ways I get around the WebMD conversation is I actually will say, "Hey, listen, I read the medical journal from Johns Hopkins." That usually goes a little better than WebMD.
Yeah.
But I don't know if there's a high research for the trademark or a WebMD version of trademark. But jokes aside, you trigger something on things that may be risque. I got a buddy of mine, state of Virginia is starting to loosen its rules around cannabis. in the use of that. Are there any, and I can use that as an example because each state is different, and of course, federal is still completely illegal. Are there things that prevent you in those type of industries where state and federal law don't match up that you got to be on the lookout for when you do your research, or do you just got to stay hands off completely?
Yeah, this is actually a huge issue right now with the CBD and cannabis industry with trademarks. So the rule from a federal standpoint is that you cannot register a trademark for any product or any service that is illegal under federal law. Okay.
Okay.
Now, that would not prevent you from registering the same trademark for the same federally illegal product or service at the state level. Every state has their own trademark registry. So if you wanted to register your trademark, and let's say your trademark is used to sell cannabis or cannabis related products, and you did that in California where it's legal, okay? You could register your trademark in the state of California, and you would have whatever rights a California state trademark registration provides you. Okay. You will have no rights at the federal level, zero, because it's an illegal product. Now, the question though is what is illegal? And a lot of people don't even know what's illegal because the federal government isn't enforcing federal law, right? If the federal government was enforcing federal law, there'd be no cannabis dispensaries anywhere in the United States, right? It'd all be shut down. It's technically illegal, and anything that's illegal under federal law cannot be legal under state law, right? It's the supremacy clause of the Constitution, right? So a lot of people, this is a very, very common one that I run into once a month. People want to register vitamins and supplements that have CBD in it. Technically, anything ingestible, food, drink, supplement, pet products, is technically illegal under federal law if it contains CBD.
Okay.
Because it violates what's called the FDCA Act, the Federal Drug and Cosmetics Act. Right now, is that going to eventually change? Yes, it's eventually going to change. But technically, it's illegal. Now, would you know it's illegal? Of course not. You go to the biggest stores in the world, Walmart, and you can buy supplements with CBD in it.
Yeah.
Right? You can buy drinks with CBD in it. No one's enforcing this. There's zero enforcement, but it's technically illegal.
Interesting.
So you cannot register a trademark for a supplement or a food product or a beverage product that contains CBD. Now, you can register the same trademark if it was used in connection with a topical product that contains CBD. So it's a lotion that contains CBD, perfectly legal. You can register it.
I'm going to go tell a buddy of mine he has the only gourmet popcorn with CBD in it in the United States, to our knowledge.
Really?
I was talking to him about it yesterday. And I'm going to say, all right, you're going to, you may be on the gut jump of something here, but you can't do anything with it yet.
Yeah, you can't register the trademark. Now, what's a way of getting around this? Well, registering at the state level is a way of getting around it if the product's legal in the state. Another way of getting around it to try to get some initial protections while the federal law is going to be, because eventually, obviously, marijuana is going to be legal under federal law. Yep. CBD, this is all going to be legal eventually, right? So one way to kind of do this is to file a trademark application for the name that you use for your illegal product, right? And you register it for something else that is legal that you're providing. One thing that's very easy to do is start a YouTube channel under this name and just put out videos about your CBD popcorn, right? And then we're going to register the trademark for providing online videos in the field of popcorn. And then you've now got a trademark registration for this name for videos in the field of popcorn. And then when the law changes, then you can file a trademark application for that name for popcorn, for CBD popcorn, and it's probably going to go through just fine. It also prevents others from registering a similar name while we're waiting for the law to change.
Awesome. Okay, I got some phone calls to make later.
Yeah,
maybe somebody to send your way.
You just do something silly like start a blog about popcorn. I mean, literally anything that would be easy to do that's legal, that has some relationship to your product.
That's crazy.
Yeah, start a podcast.
Yeah.
Literally anything. Anything. Sell some clothing with that name on it. Whatever.
Gotcha. Oh man. Well, hey, this has been fascinating. This has been awesome, and getting me to get corrected in my head between the differences of some of these things that even now, years later, I'm still confused on. Clearly, what's the best way for people to reach out, connect? You got social media to follow on?
Yeah, I do. You can just look me up if you just type in Morris Turek on Facebook, Twitter, YouTube, TikTok, LinkedIn. I'm
You
there. You
TikTok
can.
dancing?
I have one video of me dancing. It's not pretty, but it's there. I just recently started TikTok, which is kind of fun. It's
Mhm.
it's like I'm probably too old for it, but it's fine. And then obviously you can connect with me by calling me. My number is 314-749-4059, and my email address is morris@yourtrademarkattorney.com.
Awesome. And like I said, as it stands now, you are number 4 or 5 on the Google first page. By just all you even have to do is just Google trademark attorney as the keyword, and you popped up on the first
Well,
page.
that's good to hear. I
Yeah.
don't check my rankings all that often, but that's good to hear.
Yes.
I wonder if I'm ranking like that in other parts of the country, or is it just like in the St. Louis area? Not sure.
Well, they've Google's changed some stuff around. They've front loaded it with ads at the top,
Mm-hmm.
more so than it used to be. I've noticed it, and I've seen other tech guys talk about it as well. But you're definitely in the organic searches on page 1,
Hey,
on the most important keyword probably for your entire business.
hey, can't complain about that.
Yeah,
So
that's awesome.
yeah,
I appreciate the time.
no, it's my pleasure. Thanks for having me.
This has been fun.
Yeah, it was. It was a really good time.
Let me